ultimately that's less money for the front of the house people and less a burden on the employer because he doesn't have to pay that worker.
He can get away
in the
with
back
paying them less
because they're getting the tips. So ultimately, it ends up in the employer's pocket indirectly.
So workers have rights if they feel that their tips are being improperly shared.
They do. They should consult with an attorney. They should consult with the Department of Labor if they have questions about that particular scenario. But there are protections for it under the law, and very strong protections under New York State law.
Another area we frequently hear about are internships. Some people want to work. They need to learn the business, whether it's a law office or any other types of business. What are the rules for employees or interns if they want such a situation, opportunity?
Well, this was a hot topic a couple of years ago where a lot of media companies were being sued in class actions for millions of dollars for misclassifying their workers as interns. In 2015, a federal court came out, and that covers New York, came out with a decision that narrowed the rules, that expanded really what the Department of Labor considered to be the rules for those cases, but they're largely tied to academic credit, largely tied to are you really getting a learning experience rather than, many times these internships, first of all, sometimes the internships are completely phony, right? They're all people who are not in school, they're people who are not learning something, but they want to do work for some company to get the next leg up, to get their foot in the door in the business, and that is not currently allowed. So
an employer can even offer that even if someone's willing, because it's not really allowed.
Correct, because you're not allowed to volunteer. Well, if they're a nonprofit corporation, you can volunteer, right? If a for-profit corporation, you can't volunteer, so you can't just say, look, there's a lot of misclassification categories that are the question the employer asks is, how do I not pay this person? How do I make sure that this person doesn't get the money that they deserve? And then they go down the very short list of interns, volunteers, independent contractors, right? If you're an independent contractor, you really got your own independent business, right? Are you going to work for $2 an hour? Are you going to work for $3 an hour? Right? There's some economic reality that has to go along with that.
Now, what is some of the potential liability of a company if they're not honoring their obligations under the law that you've described?
Well, there is the actual damages for minimum wage and overtime, which shockingly fast add up. You would not believe how quickly that adds up, particularly when you're talking about multiple employees. Some of them are, working for you for many, many years, and you didn't pay them right in the first instance. And when they come to collect all that money, you find that could be enough to be a real serious threat to the continued operations of the business. There's also what's called liquidated damages, which is 100% additional amount on top of whatever you're able to recover.
That's like a penalty.
It's like a penalty, but the law sometimes describes it as something different than a penalty. But it is certainly more money than you would have had to pay if you paid them right in the first place.
Now, they're also liable for attorney fees?
They're liable not only for their own attorney's fees, which a litigant would, in the normal course, always have to pay. They're also liable for the plaintiff's attorney's fees. And this creates a quicksand effect, right? The more that you struggle, the more motions you file, the more you fight in court, the more you try to litigate, the more it costs you on the other side, and the more you end up paying, and the deeper and deeper you sink into the hole.
So what are some of your... And an employer also might be personally liable for these damages?
Yes, that's a good point. A lot of times employers will think that there's an issue with piercing the corporate veil, right? I set up a corporation, and you can't get me because I'm behind this shield of my corporation. That is not how wage and hour law works. That is not how these wage theft cases work. Individual executives of a corporation, individual managers and owners of the corporation where they really have the hand in the day-to-day operations of the company, those people can be held personally liable. In addition, there is unprecedented in the law as far as I know. There is, in New York State, potential liability for shareholders. So suppose you lend your no-good-for-nothing nephew $10,000 to set up his new business, and he gives you, 10% shares in the company. Well, if you're one of the 10 largest shares in the company, you don't have to ever set foot on that workplace. You don't have to ever set a boot to any of the employees. You could be potentially liable for the wage theft claims in the case.
Okay. What if someone is due a bonus or a commission? Does that come under the same scrutiny?
Well, there are bonus and commission rules. So, for instance, if there is a non-discretionary bonus, right, you meet some threshold, you automatically get the bonus. It's not, I'm giving you a Christmas present of $5,000, but the next year I might give you $1,000, right? That bonus, the employer may make a mistake. See, this is where an honest mistake comes in, because the rules aren't necessarily always intuitive. They may not pay overtime based on the actual wages when you include the bonus, or they may not pay overtime because they're providing lodging to live in on the premises and not count in the value of that lodging into what the overtime rate should be. So instead of making $10 an hour, you're really making $13 an hour because the lodging has a certain value, right? So those are some of the sort of at the margins issues where there are honest mistakes that are made.
Is there anything else any other tips you wanted to offer employers about record keeping to be in compliance with the law and protect themselves against liability?
Yeah, I think there's a lot of things that employers can do to protect themselves. One is maintain records, get a time clock, keep track of the time, so that if the Department of Labor comes knocking on your door, or if I come knocking on your door, you could say, well, I paid this person overtime. I properly paid them. Here's all the time records. And if you doctor the time records, you would be very surprised how quickly the Department of Labor can figure that out, or I might be able to figure that out. So I've seen that too. But, I think the best practice is get a time clock, keep track of the time, and don't do what's called time shaving, which is, the time records say you worked 42 hours. Yeah, and then only pay them 40. Then your record keeping is giving you away. Do not, fool yourself into thinking that there's, that you need to authorize overtime. As long as the employer knows about it, overtime is compensable. You can't require someone to get special permission to work overtime, meaning you need to work over. But if they do in fact work overtime, you have to pay them. So your remedy is not to not pay them overtime. It's to discipline them. It's to fire them for working unauthorized overtime. Don't think that salaried employees don't have to be paid, are automatically exempt from overtime rules. That's not an alternative unless the job duties that they have fit into an exemption, and the salary is enough to satisfy the exemption. And the salary requirement is another issue where there's a big fight in under federal law about raising the salary requirement. But New York has already taken the initiative and raised that salary requirement, and that's going up on a sliding scale from year to year. So that's quickly creeping up to reasonable salaries for executives.
If someone thinks they're being ripped off as a stork, should they bring it to the attention of the bookkeeper or their employer or human resources?
Yes, I will say that the first stop is usually it would recommend dealing with the bookkeepers, and sometimes an employer would know what the result is going to be, right? If they're knowingly being cheated out of overtime, and they think that employer is going to fire them for doing it, well, then that may not be the first stop. But if it seems like some sort of clerical error, some sort of mistake, some sort of, the records don't indicate this extra time that I worked, then the solution is really to go to HR, to go to somebody in the office there.
And if they got fired for speaking up, they might have some kind of claim of retaliation.
Right, and unfortunately I see that very, very frequently. Retaliation is against the law, under state law, under federal law, and also, really taints you in front of a judge. Lawsuits against you, and then there's all these retaliation claims against you on top of it. It makes you look much less credible.
Is there a deadline for bringing the claim, some type of statute of limitations?
Sure, well, that's a good question. The statute of limitations is 2 to 3 years under federal law, depending on whether or not the violation was willful, and 6 years under New York state law. So once again, New York state law outdoes the federal law by a wide margin, and that 6 years can really add up, particularly on a class-wide basis when you have employers from 4, 5, 6 years ago coming out of the woodwork to participate in this case because you didn't do what you were supposed to do.
It can be a pretty big class.
It could be huge.
Is there a charge to the client for consulting a lawyer like you?
I think that depends on the attorneys. I do not charge a consultation fee, and most of the time, if I'm working on a wage theft case, I'm on a contingency fee basis. I'm looking to get paid from the employer. I'd much rather not take money from that worker, particularly a guy making minimum wage who's
already being victimized.
Correct.
Are there some other resources you can give, such as a website or government websites for someone can obtain be they an employer or employee, for additional information?
One just practical piece of advice for an employer: if you practice in a certain industry, learn about the rules for that industry. So if you don't need to be an employment lawyer, right, and know every rule about everything. If you have tipped employees, get up to speed on the tip worker rules. If you have an issue with, like you said, driving from workplace to workplace, go look it up. Right? If someone lodges a complaint with you, go look it up. Right? But let me say that, even with respect to retaliation, even if the person is wrong on the law, if they lodge a good faith complaint, meaning I think I'm entitled to, this time before I'm punching in, but after I arrive at work, and you might win on the law, you might win on that legal issue, and you might lose on the retaliation claim because that person made a good faith claim.
Okay. Any other final tips you'd like to offer employees or employers?
I think that's it. I think employers should be standing up for their rights. You should look towards the protections of the retaliation laws, but I can tell you that doesn't.
And I meant to ask you earlier, these protections apply whether someone is legal or illegal, have working papers or not?
Well, that's a good question, because who can answer that on a federal level anymore, right? Where there are sometimes immigration agents, parked in front of the courthouses.
Okay, but I'm saying that is not a requirement for asserting these claims.
That is correct. If someone does not have documentation, they can assert their claims. They can receive the protection, and if they receive money, that money is potentially subject to taxation, right? Because it's wages. The money you're getting paid is wages. You could be subject to tax, but if you didn't have a Social Security number, then you'd be allowed to request an ITIN number, which is a special number,
and that could be dealt with at the end.
Uncle Sam to get his money at the end of the day, and still that worker can still receive the
Okay, I wish we had some more time, but I'd like to thank Attorney Christopher Marlborough, with offices in Melville, Long Island, New York, for talking to us about wage and hour litigation. Keep in mind, whatever you've heard is presented as information only. You should get your own legal advice from your own attorney or accountants. If you miss any portions of the program, you should be able to obtain a free podcast by searching WHPC on iTunes. Please join us next week at this time for another program on Law You Should Know here on 90.3, the voice of Nassau Community College, or also over the internet at ncc.edu/WHPC.